I think that covers everything. So without further ado, I'm going to introduce Matt Lynch. He is with TRG. He'll tell you a little bit more about who he is and what he does. But we had the same session in Newport News yesterday, and I can't tell you how beneficial this is for not just helping you know who you're working with as your clients and how to ensure that you're working with the right people and that they have the authority to do what they say they're doing, but also there's a lot of really great personal advice in here as well. So I'll turn it over to you, Matt.
Great.
Thank you so much.
How's everybody doing today? How's that back row? That's my favorite row to ask questions to. I'm glad you sat there today. Yeah, I see you. We're going to get you. No? Yeah? There you go. All right, so today we're going to talk about signing authority, power of attorney, estates, trusts, and conservatorships. Anybody know why? Because you need 2 credits? Is that it? Right? There he goes. They can hold up your closing. Yes, that's right. So I'm with Title Resources Guarantee Company. We are a title insurer. So we're the company that I'm the attorney that helps Molly and her team and Jolene and her team get your cases to the table. So whenever you have a particular case and there might be an issue, we're the company that sits there and works through resolving that, and then ultimately insures it so that your buyer has no problem when they actually go to sell, right? So that's what we do. So we're here to get you to the table. We're not just that extra fee on the settlement statement, right? We actually serve a purpose. So in today's class, we're going to talk about when does a person have the authority to sign on behalf of another person? Anybody? Power of attorney, that's one thing, right? You're about to go to a listing agreement, a listing appointment. You're about to sign that. You're about to sign that big whale for yourself. What are you going to do in preparation for that? You're just going to show up and waste your time if not everybody's there? Go to the tax records and find out who actually owns the property. And then you're going to make sure that everybody on that tax record is going to be at your appointment. Otherwise, what's the point, right? You're just wasting your time. So if John and Mary own a property and Mary's not there, what are we going to do? We're going to reschedule. We're going to start asking questions, right? Where's Mary? So now John's going to sign for Mary. What hat is he wearing? What capacity is he signing for her in, right? So he's going to act as her agent, right? And we need to know in what capacity he is as her agent. He could be a power of attorney, attorney in fact. So that means that Mary's alive and that Mary's given him a document to sign on her behalf. She could be dead, right? They could be out on a little dinghy out in the Caribbean and Mary's no more. What happened? Too soon? All right, she was in Aruba and went swimming and now we don't know. But, okay, now she's dead. What are we going to need? What are we going to ask John for? We want her death certificate. What else? Will. What else? She's dead. We might want to ask for a copy of the current deed. Why? Because if they were married and they held the property as tenants by the entirety, all we would need is a death certificate. Right? That's it. That speeds everything up. What if they tell us the property's in a trust and John's the only trustee that needs to be there? What do we need? How about we get a copy of the trust, right? Mary's incompetent. She doesn't have a power of attorney. She's still alive. Who can sign for her? Nobody. We need to go to court and get a guardian/conservator appointed. What if I have kids from a first marriage and I'm married and I'm now in a second marriage? I don't have a will and I die. What's going to happen? It's going to be a mess. It's going to be a steaming mess. It's going to be a mess, right? But my kids are minors. And now we're going to try to go sell that property. Who can sell that property? Can Can the kid's mother just step up and sign for them?
No.
No, we need a guardian for the minor, right? We need a guardian for the minor. The kid, the surviving parent can be that guardian, but they have to be appointed so by the court. Just because you're the parent doesn't mean you're the guardian of that minor's estate, okay? You have to actually be appointed by the court. Why do they do that? Anyone? Remember our little kid TV stars? Did all that work and their parents stole all their money? Britney Spears, right? Right? So now that guardian's going to have to make accountings to the court each year until that kid becomes of age, right? So these are kind of the things we're going to talk about. And our goal is to make sure that when you get that listing appointment scheduled, you know at least some of those questions to ask. Why do you want to ask those questions? Because what's worse than a surprise at the table? Do your clients like them coming back to them 3 or 4 times, keep asking for information? Now they have to get this, now they have to get that? No, they don't like that, right? So you asking all the questions up front makes you look like you know what you're doing, right? That's going to give them a better experience and get you that 5-star rating, right? That's what we want. That's our goal. We get that 5-star rating, then other people start using us, right? Our reputation builds. So when I'm acting for somebody else, what's the level of care I have to exercise? Can I just do things because I want to do them? No, right? So the role I'm in, regardless of what hat I'm wearing, is called a fiduciary. And that's an individual whom another has placed the utmost trust and confidence to manage, protect property or money, and I have a duty to act for that other person's benefit. I have a duty to avoid self-dealing and conflicts of interest, which mean I have to put that person's interests above my own, right? So if I'm my mother's attorney in fact, right, can I just transfer her property to me, right? Maybe, if the document allows for it, right? But what are my siblings going to say? They're going to hold me to the fire, aren't they? Right? So I can't just act on my own. I need to put that other person's best interest ahead of my own. Because I'm in that position of trust and confidence, the courts are going to hold me to the highest level of care, right? I have to really be on my game, right? I have to account for all the dots on my I's, all the crosses on my T's. I have to account for every penny, right? I have a duty of care and competence, which means I have to act as a reasonably prudent person. What was yesterday? Tax day, right? So I'm just some fat title guy, right? I sit in a desk, answer questions all day. If I'm doing my mother's taxes as a title guy, I bring my reasonably prudent person standard. But if I'm a CPA, right, I have to bring all that knowledge and experience as a CPA when I do that job for her, even though I'm just her attorney in fact, right? Because I'm not just her attorney in fact, I'm also a CPA, right? So I have to bring that to the table with me. I have a duty of loyalty, avoid self-dealing and conflicts of interest. What if my mother had already agreed to sell me the property and we had a contract to that effect? Could I then complete that transfer to myself? Yeah, because she signed the contract. It wasn't a contract that I signed, it was a contract that she signed, right? So as long as she was competent, then there'd be no problem in me as attorney in fact completing that. It might look bad, but it could happen. Confidentiality means I can't go running around town telling everybody her business, right? I only disclose what I need to disclose for those purposes. I have to act in good faith. If I know that this is a bad decision for anybody, I don't want to be doing that for her, right? Where do my powers come from? As a power of attorney or as a trustee, they're going to come from the terms of the document. I have to look at the four corners of the document. I can't go outside that, right? So it's important that you get a copy of that power of attorney at that first appointment so that it can be reviewed to make sure that what they're trying to do is even contained in the power of attorney, right? So we want to make sure that that they can do what they're trying to do. Anybody go online, pull down their little documents from those little legal websites? You're not going to pay an attorney, right? Well, guess what? They don't always necessarily comply with Virginia law. They also don't necessarily contain all the powers that you need to do the things that you want to do. So we want to get a copy of that to make sure that it does. I had one just this week. Just this week, and on the top, Virginia power of attorney. But it didn't contain the power to sell property. It contained the power to manage property, like do leases and stuff, but they couldn't buy real estate with it. They couldn't sell real estate with it. They couldn't mortgage with it, right? So for the purposes that they were trying to use, none of those powers were there because we are confined to the four corners of the document. For things like a administrator or a conservator, we're going to look to that court order to see what that says. And then you want to keep records. You want to keep records. Anybody got siblings? Anybody act as the attorney in fact for their mother or father or whoever? And then get those siblings to start asking questions, right? When you're the one that's burdened with that job, right? They're going to. Because the first day in law school, you know what the first lesson is? Without family, we don't have law books. Them siblings are coming for you. Everything's fine and good when you're doing all the work. Then when they don't think they're getting something, guess what? Now they're going to start ringing the bell, right? So you want to keep register. You want to be able to account for every penny and what that was spent on so that they can't accuse you of taking that money for yourself, right? Because I've seen it happen. I've seen it happen before closings. I've seen it happen after closings. I've seen it where people come up after closing and say, how did mom sell that house? Title company says, oh, we had a power of attorney executed just 30 days ago. How was it executed when mom's got dementia? Is that a good power of attorney? Should that title company have accepted it? What do they have now? What she said. It was a hot steaming pile of mess, right? So it's a problem. It becomes a claim, right? And now we got a lawsuit. We got people that are fighting over it. And now we got a buyer who's got a property that now the title is now in question, right? So it becomes a huge problem. So a power of attorney is a document where the principal, the person, like my mother, she appoints me as her attorney in fact through a written document, and that to become her attorney in fact or her agent. The document doesn't have to actually say the word power of attorney or say the word attorney in fact. It could say agent, but we have to read the document to see what is contained in it and what powers are intended to be transferred. They're extremely powerful documents. Anybody know why I got that little graphic on the bottom?
Pay them all.
I wouldn't do that in check. I'm from Jersey. It would be in an envelope wrapped in a newspaper. Come on now. All right. So, because a power of attorney is a very strong document, especially a general power of attorney, right? It's not limited to a specific transaction. I'm giving somebody power over all of my assets. So what it's like is it's like me handing over my checkbook and pen to that attorney in fact and say, here you go, you now have control over my assets, right? Is everybody ready to do that? No. You should be. What happens if you leave here today and get in an accident? Who's going to handle your affairs? right? You don't have a power of attorney, your family's going to have to hire a lawyer and open up a conservatorship case, which means they have a lawyer. You as the disabled person has a lawyer. There's doctors involved. They got to be paid. Once the conservatorship gets established, there's going to be an ongoing accounting to the court every year, which means now we got accountants. Takes a lot of time and money to do all that, and that time and money doesn't go away, right? Having that power of attorney could have alleviated that. So who needs a power of attorney? Everybody. When do they need it? Now. Who are we going to call? We're going to call Molly. We're going to call Molly. We're going to call Shaheen, right? We're going to say, hey, I want to sit down and talk about putting an estate plan together. Here's my situation. The documents may be all the same, but what's in those documents is going to be crafted to your situation, right? Or do you just have the one marriage and all the kids are within that one marriage? Okay, great, but what if it's a blended family, right? What if you have a special needs kid, need to make different types of provisions in that estate plan for there? You need that now. If you wait until you need to have a power of attorney, it's probably going to be too late, right? Because you didn't execute them, and now when it's needed, you don't have it, right? So talk to Shaheen now. Get your estate plans put in place if you don't have them. Think about it. Very important stuff. So with the power of attorney document, particularly if it's a broad document, the agent can do anything the principal can do with the document, as long as the power that they're trying to exercise is within that document. Okay? So we're limited to the terms of the document. If they're trying to do something that's not listed in the document, if it doesn't specifically say we have the power to sell and convey mortgage or sell and convey real property, then it's not there and it can't be used. Okay? So prior to settlement, that document's going to have to be reviewed. If you know Mary's not going to be at that listing appointment with John, make sure that John brings that power of attorney document, because you need to get it reviewed to make sure it can even be used, right? We got to also make sure that it's even valid. What if that power of attorney was issued in Ohio or Maryland? Can we use it?
Nope.
Maybe.
In Maryland or where else?
We can use an out-of-state power of attorney as long as it's valid in that state. Then it will be valid here, but we got to review it to make sure that it's valid. Maryland has different requirements than Virginia, right? They get all uppity across the river, right? Oh, we're the free state. No, basically in Virginia rather, all you have to do is you have to sign that document in front of a notary public, okay? It's financial power of attorney. We sign it in front of a notary public. It's going to be good to go. Not so in Maryland. In Maryland, you also need 2 witnesses. So if it's a Maryland power of attorney, we got to look at it and say, okay, now it's valid there. Now we can use it here. But if we look at it and it's clearly a Maryland power of attorney, but it doesn't meet Maryland rules, we can't use it here. Okay? So very important that we get that document and review it well in advance of settlement, right? We want everything collect as much information as you can up front. Title company is then going to contact the principal to make sure they're aware of the transaction, right? Very important. We had a situation in DC, came through my company about 15 years ago, where it was a forged power of attorney, right? The principal was actually living in Queens, New York, in an assisted living. Property was in DC, so the property was basically unoccupied. Tax bills were going up to New York. It was a forged power of attorney. title company did not contact the principal or the principal's family to confirm that they were aware of the transaction. So that document got recorded, and the bad guy did a couple of cash out refinances, right? Then he sold the property to an unsuspecting buyer. Well, here's the problem. In that first transaction, that document got recorded. By statute, an examiner is allowed to rely on a notarized signature as being valid. So he had no reason to question it. The title company has used it a couple times on a couple transactions, and it's recorded, and by statute we can rely on a notarized document as a genuine signature. So it just kept going on. Had that title company called the principal during that first transaction, all this could have been stopped. So that buyer sells the property again. Family finally gets wind of they don't own the property anymore. What do? They sue everybody, right? They sue the current owner. They sue any realtor they can get, any title company they can get. They sue everybody because they're trying to get their property back. Thankfully, our buyer had title insurance. Title insurance was able to settle with the victim's family so that they keep the house and the lender stays in place, right? What happens if he didn't have title insurance? Who's going to pay that? The buyer's going to have to pay to defend himself, right? Now, not to embarrass our good friends back here, but because they charge a reasonable rate, but how much do attorneys charge in this area? Right? They charge a lot. I can tell you, looking at files, first 10 hours of an associate looking at the file, just figuring it out, that's just looking at that's not doing anything. That bill's just going cha-ching, cha-ching, cha-ching. Had they had title insurance, those attorney fees would have been taken care of, right? So very important to have title insurance. We're also got a little louder.
Do you mind if I ask a question? Or would you rather not wait?
No, go ahead. I just can't hear you.
Oh, okay. So what happens to the title company that should have done their due diligence to?
The underwriter would go after them for what they've sold.
What's that?
The underwriter who paid the claim would go after them. Yep. No one gets off the hook. That's assuming they were even still in business. That's another risk. The original company's out of business, right? Remember, before 2008, there were a lot of people getting in real estate. Then I'd be sitting at settlements, and people would be attending the settlement, asking a lot of questions, saying, "Oh, I used to be in real estate." Well, there might be a reason you used to be in it. So, you know. But people, you know, who was that entity? Are they still there? Yeah. Yeah.
Was there any liability for the agents that were a part of those deals, even though, you know, the title and insurance?
When a plaintiff's attorney sues, they cast a big net to try to get something out of everybody. So they might have the realtor and they might have settled. They might have taken it out.
The realtor in the initial person who did the fraudulent document.
Well, it initially started out as cash out refinances. Yep. And then they sold it. They thought they could sell it. They thought everything was good because we got a recorded power of attorney. You assume the other company did their due diligence. So, bad assumption these days. The bad guy in that case, this is the truth. Bad guy in that case actually got a presidential pardon from Bill Clinton prior to that act and had done it again.
What?
Yep.
Oh, really?
Yep. Yep. You're gonna, at that listing appointment, you're gonna want the original document. Why? Because we have to get it recorded, right? So when our next searchers are going to do the next search, and it says that a power of attorney was used, we can go back to that power of attorney document, make sure it had the powers listed, make sure that person actually was that attorney in fact, things like that. Okay? Yeah.
power of attorneys have like a court seal on it or something to say that is legit?
No. The court is only recording it. When you go to execute your power of attorney, you're going to do it in front of a notary public, right? And he seals it, that you met with him and you acknowledge that you signed this in front of him, and he seals it, right? Then we get it recorded. The recording of it's the only part that the court's involved in, because the court is a public record. It's a public kiosk. You go to the supermarket or out here in the library and you see everybody puts their little notices up, puts their business cards up. That's all the land records are. It's just some place, a central place for all the records to be posted, right? Okay, so as underwriters, we all require, no matter if it's my company or my competitors, in this day and age, we all require that that power of attorney gets recorded at the courthouse. I'm saying that because Virginia, I mean, they just passed 1,000-something bills, right? Why couldn't they put a bill together that requires the power of attorney to be recorded? Let's help stop some fraud. I guess we got other things to worry about than fraud. But so as underwriters, as insurers, we require that that document be recorded at the county. So that when we're looking at that title, if John's saying he's the attorney in fact for Mary, there's a document on record that I can look at that shows John is the attorney in fact for Mary, and it was signed by Mary and it's notarized. And he had the power to do what that he wanted to do. How he signs, I'm a principal by James Court attorney in fact, right? Why does he want to sign that way? He's telling the world that it's I'm a principal's obligation and not his obligation, right? So if Jeremy is my attorney in fact, and he goes to attend my refinance for me because, you know, I'm entitled, so I'm on a fancy vacation. Never happens, but, you know, I can dream. He goes to sign those refinance documents. If he just signs Jeremy Williams, whose obligation is that? Is it mine or Jeremy's? It's Jeremy's. But if he signs it all out that way, then it's my obligation. So he wants to tell the world that it's my obligation, not his. He's just doing a good deed. And look how much he has to sign. We call that proof that no good deed goes unpunished. He's going to have to, like he's in school at the chalkboard, just keep signing 500 times. I'm a principal by James Court attorney in fact. All right, any questions on that so far? No? Okay. All right, there are various types of powers of attorney. The first one is medical. That's over your person, right? If you can't make decisions for yourself, who's going to make those decisions for you? You could be in a coma. You could be on medication that makes you loopy. You can, you know, for some reason, you can't make a competent decision for yourself. So the document's going to say who gets to make those decisions for you. The whole next group is all financial powers of attorney. So it could be general, which is, like I said, broad, covers basically everything. Or it could be limited and specific to a particular type of transaction. For instance, the sale of 5 Oak Street, or the purchase of 10 Spring Street, whatever. Okay, it could be limited to a particular transaction. Next up, we have military. A lot of military powers of attorney down here. A lot of buyers using military powers of attorney. All the military power of attorney is, it says that because we're in the military, we get to take advantage of federal law. And there's a big preamble at the top of the document that says, regardless of what the state requires, the federal law is going to control, and it's going to be good even if it doesn't conform with state requirements. Best example of that, I already brought up Maryland, where they require both a notary and 2 witnesses, right? So if someone's trying to use a military power in Maryland and they don't have 2 witnesses, because it's a military power of attorney, it trumps the state rules, right? it has more, it gets to be used because it's federal, right? The final box down there is springing. What does springing mean? Okay. Correct, after something happens. So the document contains a triggering event. My attorney, in fact, does not have the power to act until that event has been triggered. Typically, it says that it doesn't get triggered until I've been determined to be incompetent. No jokes. No jokes. So how do we determine incompetency? First thing we're going to do is we're going to look at the document, right? Because the document may have less stringent requirements than state law, okay? And that's okay. But if the document doesn't have anything about that, we're going to need 2 medical doctors to determine that we're incompetent. Time and money, right? Not a certified nurse practitioner, not the facility administrator, a licensed physician, a medical doctor. That's what the statute calls for. We often get letters that are signed by certified nurse practitioners or whatever. They're not licensed physicians. The statute requires a licensed physician, right? Which can be hard to get in some places, right? Because maybe only in your area, maybe you just got PAs, physician's assistant. Physician's assistant is not a licensed physician. They are a physician's assistant. So with springing, we have powers of attorney. When are they effective? They could be effective immediately, right, which is what we like to see, or springing. If I have a springing power of attorney, and I'm going to Shaheen Law Firm to conduct my settlement, right? And here it is, Matt's signing for his mom. We're going to sell that real estate. But the document says I don't have the authority to act until mom's been declared incompetent. What's Shaheen going to do? They're going to ask for evidence that she's incompetent. Otherwise, I don't have the power to act, right? My statement to them hopefully is not enough, right? They want to ask the question. They want to get the documentation that mom is now incompetent. So a springing power of attorney, while it's great because it can give some control over when that attorney in fact can access your assets, it's not always ready to be used in the event of an emergency, because that third party you're asking to rely on it has a duty to ask the questions, right? They have a duty to ask. So immediate, it's going to be effective now. Springing, it's going to be effective later, right? Little now and later. That's a good Halloween joke, but we're not in Halloween. Maybe Easter candy. Put that in your kid's Easter basket. Little now and laters. All right. So, any questions on springing? Yes.
Not on springing, but there was another type that was called durable power of attorney.
We're going to talk about durable. Mm-hmm. Yep. So a durable power of attorney. Did we talk about that yet? We'll talk about that in just a minute. So powers of attorney are only good during your lifetime. Okay? As soon as you pass, that authority just went away. Right? So now I've already appointed Jeremy as my attorney in fact. He's helping me with the sale of property. Right? He's the one that's scheduled to go to the title company to sign the documents to the attorney's office. But in the morning that he's going to sign, he didn't give me a call to let me know I was on my way, that he was on his way. But I died overnight. He shows up at the office to sign the documents. Is that still a good transaction? It actually is. Because Jeremy doesn't know that I died. So by statute, because he didn't know that I died, That's still a good transaction. Now, don't be surprised at all should the attorney and title company call up and say, we want to get another deed signed by the executor or by the heirs, just to wrap everything up so that there's no loose ends, right? But technically, those documents that he signed, because he did not know I was dead, are still good. What are we going to make him sign at settlement? We're going to make him sign an affidavit of authority that as of that moment, he didn't know that I had died. He didn't know that his power had been revoked, right? Had he known that his powers had been revoked or that I died, then any action he'd taken would have been fraudulent, right? But he didn't know, so everything is good, okay? I wrote this during the US Open. Just got back from my friend's funeral. He was killed by a tennis ball. It's a lovely service. I should probably switch that to pickleball, make it more topical now, right? Oh, does anybody still play tennis? All right. Durable. What does durable mean? Does that mean it's Yeti tough? We're going to bounce that thing around, nothing's going to happen? It's going to keep our ice as ice for 10 days? Right? No. A durable power of attorney is one that allows the attorney, in fact, to still act even though the principal is incompetent. Okay? So, very important. Back in 2010, Virginia adopted the Uniform Power of Attorney Act, which allows us to look at a power of attorney that's dated anywhere from 2010 forward and assume that that document is durable. Prior to that, if a principal became incompetent and the document didn't say that it would survive the principal's incompetence, then the attorney, in fact, had no power. We weren't allowed to take it because we had to know at that very minute when those documents were signed that the principal was also competent, right? And unless it said that, we didn't know, so we couldn't accept it. Now we can assume that it is unless the document says otherwise. So we're still going to review the document for durability, but what we're looking for is a clause that doesn't say that it's not. Okay? That's what durable means. So that it continues to go even though the principal has now been declared incompetent. Okay? Very important. I'm sorry?
In which circumstances people choose to go with a durable power of attorney?
When should it be used?
Somebody that doesn't trust somebody. But then why would you pick that person to act for you anyway? Right? That's it. Because you want it there in the event of an emergency. So if it's not durable and something happens to me, it can't be used. Right? So you want it to be durable. What else does it mean? Non-durable means that the authority of the agent ceases should they become disabled or incapacitated, i.e. incompetent. Incapacitated means that they meet the grounds to have a guardian of the property appointed because the person was unable to manage their own affairs. Or they're missing or outside of the U.S. unable to return. Right? They're a prisoner of war maybe. Whatever. So they're unable to return. So we want to make sure that it's durable to make sure it can be used regardless of the principal's condition. Right? If you were meeting with your attorney, I'm sure that that's what they would talk to you about. Correct? Lots of bobbleheads back there saying, yep. All right. So next up, anybody have any other questions about powers of attorney? I'm sorry?
Oftentimes, I'll have a power of attorney should act for just one transaction, but you're saying a lot of times they're just indefinite until you revoke.
They can be for one transaction. That's up to the person.
But otherwise, the power of attorney stays that way.
It depends what's in the document. When you met with your lawyer, what did you want? What picture did they craft for you? If I'm going away on a trip, if I'm going on an extended vacation, and I know that this sale is taking place while I'm away, I may appoint Jeremy as my attorney, in fact, just for the sale of 5 Oak Street, because that's all I need him for, right? I'll be back. I don't want him handling my other affairs. I just want him to help me with this, right? So that could be limited to this, okay? But if I have a broad estate plan, right, I want to put something together now so that I'm covered for whatever situation. I may also have a broad one in there to cover certain things. Who can be appointed the attorney in fact? You can appoint anybody as your attorney in fact, right? Medical power of attorney, financial power of attorney, they don't have to be the same people, right? I could appoint my son to be my financial power of attorney. I could appoint my daughter to be my medical power of attorney, right? I probably want to flip that, but you know. But yes, you know, based on my family situation and your family situation, you would pick who you think you want to make those decisions. You could select more than one person who can either act on their own or they have to act together, right? It's your document, it's your plan. You're going to meet with your attorney to put that all in place, right? So anybody can be that attorney in fact. Anybody can be, you know, you can limit it on, hey, they have to act together. Maybe that's a better control than I'm incapacitated. Because now you got 2 people that have to act. And then you can name a successor who can step up in case something happens to the other person. It's your plan, right? And that's what the attorneys are there to do. They're there to put that together for you. You're as realtors, especially listing agents, when you go to that appointment, you want to make sure that you get that document and you know, and get it reviewed right away in case there's problems. If you have a buyer using a power of attorney, right? Not only do we want the title company to review it, we want the lender to review it to make sure that they're okay with it. There are lenders out there that will not accept a power of attorney. Yes?
If it's a legal document, how do they have the choice to not accept it?
It's called the golden rule. They have the gold, they make the rule. Can't force them to do business. They don't have to accept it, right? Yep. So that's, I mean, it's really that simple. In their guidelines for borrowing, because they're going to sell the loan on the secondary market, and in their guidelines on what's going to go in that block of loans they sell, maybe it's restricted from that. Exactly. Yep. I mean, most companies will, but there are companies out there that don't. So, you know, you want to know that ahead of time. It may be that the lender doesn't like what's in the power of attorney. Maybe it wasn't clear. Maybe it didn't specifically say the power to mortgage or encumber the property. Something in there that the lender may not like. The important thing is it can't be a surprise to the lender. You want to give the lender as much time as they can to review the document and approve it or not. All right. We're at a good point to take a lunch break, right? Yeah. What? Yeah, it's a 100-minute class, so we'll do good. We'll take a 10-minute break now. Back at 1, and be ready to go. We'll talk about estates, trusts, and conservatorships. All right. Let's go ahead and get started. So who has the authority to sign for a Virginia estate? Who? We sure about that? If we're in another state, almost every other state, that answer might be right. What? It could be anybody. It could be the heirs. It could be the devisees under a probated will. It could be the executor. So the answer in Virginia is, it depends. There is no clear-cut answer. We have to look at the facts of the situation, which always makes it fun because who's supposed to sign? I have a case right now. People did a life estate deed. Life estate deed is like a transfer on death deed. Person dies. The 3 kids were supposed to get the property. All well and good. But now 2 of the kids are suing the 3rd kid, alleging that the mom was incompetent during the time she signed this life estate deed. They're not fighting over the real property, they're fighting over other assets, but guess what? They're challenging mom's competency when she signed that deed. Now I can't accept that deed. Now what am I going to do?
How do you prove that?
It's in the lawsuit. That's all I need to see. I don't have to prove it. Now I need it to be resolved. Right? So now I need the 3 kids to come to an agreement and the executor to join in with them in order to clear it up so we can sell it to the next person. Yeah.
Would their rights be, like, wouldn't it be considered durable unless stated otherwise if it was written after 2010?
It wasn't a power of attorney, it was a deed.
Oh, okay.
Mom signed it herself, and now the kids are alleging that because of other assets that were monkeyed with, the kids are alleging that mom was incompetent during the whole process. I can't accept that deed. It's in the court. It's in public record. They're fighting over it. Right? So now I got a problem. Huh? Yeah, exactly. I did all this work for her. I'm entitled to more. So, who signs? It depends on the facts. What's the date of death? Who died first? Is there 2 people on title? Who died first? What's the tenancy? Anybody know what tenancy is? Just a fancy word I like to throw around on a Friday night. Hey, what's your tenancy? Married couple wants to take by tenants by the entirety, right? Tenants by the entirety signifies it's a married couple, and that should the first spouse die, the second spouse owns everything, right? All that surviving spouse needs be the death certificate. It's very easy. If a boyfriend and girlfriend are buying a piece of property, right? They're not married. They can't take by tenants by the entirety. So now they have to decide how they're going to take that title. It's going to be joint tenants. Is it enough for the deed to say joint tenants? No, because there's no survivorship provision. In order for the surviving joint tenant to inherit the whole property, the deed has to have the words joint tenants with rights of survivorship. If it doesn't, that means that surviving joint tenant owns it with the deceased person's family. Let me put that in perspective for you. I own a piece of property with Jeremy. I die. We're joint tenants. There's no right of survivorship. I die. Jeremy doesn't own the whole thing. He still owns his portion. The other half is now owned by my estate. I would like everybody right now to take a moment of silence and say a small prayer for Jeremy because my family's going to tear him apart. Right? They didn't have the proper exit plan in the deed. Right? Important for you as real estate agents to advise your clients to think about that when they go into the title company portal or the attorney portal and select how they want their title to be. These things make it, there's a reason we ask these questions. It's that exit strategy. How do they want it? If it's a married couple, is it enough for the deed to say husband and wife and not say tenants by the entirety? No, it's not. That means that even though they were husband and wife, and the wife died first, right? Her estate steps up. The husband doesn't own the whole thing. That could be a problem. right? It's an unintended consequence. So let's be the professionals and let's advise them, hey, this is what you want to do. This is what that means, right? They don't know. They're not in the business, right? They're looking to us. They're looking to you, right? So we want to make sure that the tenancy is addressed. Next up, did they die testate, meaning with a will, or intestate, meaning without a will? Very important. Can an administrator in an intestate estate sell real property? If I die without a will and the court appoints somebody to handle my estate, can that person sell real property? No, not without a court order. Right? So it makes a difference whether or not I had a will. Right? Because in an intestate estate, the title to real property, as they say here in Virginia, drops like a rock in the heirs. As soon as I take my last breath, my heirs now own that property. Any baggage my heirs have now attaches to that property. If I got 3 kids and one's a financial mess and has all kinds of judgments against them, those judgments have to be paid when that property gets sold. Because title is now in that heir, and now those judgments attach. So when they go to sell, they have to be paid off. Who needs an estate plan?
Everybody.
When do they need it?
Now.
Who are we going to call?
Shaheen.
There you go. All right.
So there's no way
Yeah.
that you could, that the heirs could protect themselves if one of the heirs have made judgment?
It was the decedent's property. How's the heirs going to protect himself? The decedent should have put a will together to protect that. Mom, who owned the property, should have put an estate plan together to account for that. She didn't. She didn't do anything. So now, law says that all the heirs are entitled. So now, any baggage the heir has is now attached to that.
So that comes off of the top, and then the other.
And then when they make final distribution, 2 siblings are going to have a conversation about how much that third person gets, right? They're going to have a side conversation. But yeah, that's the way it works, you know. If I have to pay off that judgment, why should it come out of the other 2's share? They're going to have a conversation. Is there a will? What did it say was supposed to happen? Right? We want to look at that. Was the property, was 5 Oak Street supposed to go to Johnny? Or was it supposed to go to the residual, to the pot that gets split up later? Right? If it was supposed to go to Johnny and Johnny has judgments, those judgments attach. If it was supposed to go to the residuary, to the pot that gets split up later, those judgments may not attach. So it all depends on the facts. The facts change. You have a question?
A trust prevents other judgments and liens.
Depends. Depends on when it happens. A person who puts a trust together, Matt Lynch puts together the Matt Lynch Revocable Trust, that doesn't shield judgments against me. They still have to be paid off. I can't hide from my own creditors. As to my beneficiaries who get it later, that depends on whether or not that's going to be protected from them. Is it going to be a specific gift to Johnny? Then maybe not. Maybe it's not protected. If it's going to be part of the pot and he's just going to get some proceeds, that's different. Or it's going to be held in trust longer for whatever reason. So it all depends on the facts. There's no easy answers is what I'm trying to say. So upon the death, the interest in property will pass either pursuant to the title. You know, we're going to look, is it tenants by the entirety? Is it joint tenants with right of survivorship? Or is there no survivorship language? If there's no will, it's going to pass to the heirs. If there is a will, it may pass to the devisees, the beneficiaries under that probated will, or to the executor. Depends on what the will says. So we got to take a look at that. Why do we have probate? Why do we even talk about probate? What's the purpose of it?
So they can get some more money.
Okay. They seem to be doing pretty good at that. Probate is an administrative process that takes the title from person A and delivers it to person B. Okay? So even if I don't have a will, I'm still recording a list of heirs at the courthouse. That's still a probate process. That still happens, right? That's how we document how it gets from A over to B. Okay? It's that probate process. Without a will, okay, we follow the list of heirs. Okay. With a will, we submit the will to probate and do all those things. Yeah.
So I just dealt with, like, the end of last year, a deal that was going through some issues with probate will. There was a will. Somebody said the will didn't list the right way. The person who passed away had 2 children that had passed away that predeceased her, and 4 that were living. Her will only listed the 4 that were living. One attorney said that it didn't matter. She had kids that predeceased her, so those children's heir, those 2 kids' heirs still had claim to the property, even though the will listed the 4 living children. But because it didn't say that she wanted to, I don't know what the legal term is, like, not include the predeceased children, that they were to be included. So there was a big mess about it. But probate said that...
So somebody was suing to try to force a settlement.
Well, nobody was suing. They were just trying
No?
to figure out who needed to sign for,
Right.
trying to sell it. But when we took it to probate, they said they didn't have anything to do with who gets it. They couldn't say, even though they had a copy.
Because it's not the probate clerk's job to review or interpret it.
Right.
Their job is to act as a public record. So they take that. Now, if there's a dispute and somebody's filing a motion, whatever, yeah, then the court gets involved. But just your regular probate clerks, no, they're administrative. They're taking that will and they're filing it, and this is what it is, and the documents look right, and we're going to record them, and this is what the documents are. We're not interpreting them. We're not doing this, that. Now if there's a dispute, right, and let's say the executor was appointed, but they want him removed, right? Well, then the court's going to get involved and overview that. But typically, there's not a whole lot of court action, like when you think of like a judge coming in and doing
We
that.
had 2 attorneys review, and one said this is, the deceased children's heirs needed to be included. One said that they didn't.
Because it's a testate estate.
Yeah, and so it was, Shaheen took care of it.
Shaheen took care of it. Woo! Yep. Yeah, so it sounds like somebody's trying to, somebody represented.
In that instance, they would just have to, like, essentially, if there was a dispute, if the siblings were fighting about it, then they would just have to, like, proceed to court, because I was under...
They would have to proceed to court if they couldn't come to an agreement and they were actually like an actual dispute. Yeah, they'd have to get that resolved before we could pass title. Yeah. We don't want our buyers walking into a lawsuit, and we don't want to walk into a lawsuit either. Yeah.
I got a question. If a husband and wife buy a property and it says tenant,
Tenants by the entirety?
tenants by the entirety with right of survivorship, that was in 2005. In 2014, there was a deed from the husband that gifted it to his LLC, because at that point they had been divorced. So he gifted the property to his LLC. If there's no deed in the middle that proves he was allowed to do that by himself,
Once they're divorced, then he can sign his interest away.
but at that time, then the LLC would own half and the wife would own half.
Correct.
If there's no document that removes the wife from the deed, then that
The wife still owns her half.
still owns her half. Okay.
Yeah. Now, had they still been married, the deed to the LLC wouldn't be any good until the wife signed also,
So she also
because they both have to sign. Because they were divorced.
their share, They can't do anything with it sold.
Correct.
Or does it depend on what the separation and divorce decree says?
Right, so if they, let's say when they separated, there would be some type of property agreement, but that would still have to be recorded from a deed standpoint.
Once that divorce decree comes down, tenants by the entirety no longer exists. Now they each own, they're considered what we call tenants in common. Here's his share, here's her share. He's free to convey his share to his LLC if he wanted. She still owns her share. As far as the divorce and a separation agreement, yeah, we'd want to look at that to see what it said, right? I have a case right now. The people were divorced 5 years ago. That's when the divorce decree was entered. The property was in the husband's sole name. Everybody initially was like, oh, great. He can, they were divorced 5 years ago. It's in his sole name. He can just sell the property. Not so fast. The separation agreement, which we asked for, now says that the wife had a right of first refusal. She got to occupy the house for 5 years after the divorce, had a right of first refusal for 5 years, which is not expired yet. And even after that, the husband, when he goes to sell the property, is required to have a real estate agent in the transaction. That real estate agent sets the price. And there's other things about reimbursements and the split and all that. But because we have this separation agreement, the wife, who was not originally on title, is entitled to part of the proceeds. So she is involved even after her 5-year right to occupy and her 5-year right of first refusal would have been passed. So it's very important that in a divorce case, we get that separation agreement.
It gets a little more complicated.
Shaheen, you want to come up?
The new wife enters the picture.
Uh-huh.
The husband passes away.
Mm-hmm.
The LLC is a single member LLC where he was the sole registered agent.
Yeah.
The new wife becomes the executor of his estate. Does that mean she automatically takes his LLC and now owns his share of that property with the
For the estate, as the qualified executor, she controls his interest in the LLC. Now, how it gets distributed ultimately, that depends on his estate. Was there a will? Was there not a will? Things like that. So here's a good one. Here's a real case. Gentleman owns his property in his sole name, right here in Virginia Beach. Right? Got divorced from his first wife, has a kid with the first wife, who's an adult now. Property still in his sole name when he dies. He marries again. He married, so he got divorced, married again. The son from the first marriage doesn't get along with the second wife, so the family becomes estranged. Dad dies. Dad dies intestate without a will. Now, the wife files a list of heirs. She's the surviving spouse. Property was still in his sole name. She files a list of heirs. Only problem is she doesn't name the son as one of those heirs. Do we have a problem? Yes. We have a huge problem. I'm jumping ahead here, but so what happens is son finds out dad died because they hate each other so much she didn't even tell him his dad died. He's now looking for his interest in the property, which has been sold, right? Because she filed a document with the court, list of heirs, so she's the only heir. Son comes up and sues the current buyer, the current owner, and the surviving spouse, and anybody else he can get his hands on. Why? Because he wants his money. He's entitled to 2/3 of the estate. If you don't have a will, and you have children outside of your surviving spouse, that surviving spouse only gets 1/3 of the estate. The children split the 2/3. And if there's only one kid, he gets the 2/3 and the wife only gets 1/3. Right? So who needs an estate plan?
Everybody.
When do they need it? Who are you going to call? Shaheen. There you go. There you go. You guys are doing great.
Shaheen loving it.
Yep.
We did not ask him to do that, by the way.
There was a comment over here.
I'd like to comment, for those that don't have an estate plan, and because they don't, there is, you can do, and I've had you do this a number of times, just to expedite things so that you don't leave your estate if you drop dead tomorrow, a deed on death that they could do that.
That's a different type of tool. You still need an estate plan. You still need powers of attorney. You may want to also consider having a living will, right? There are other assets that you may own that you may want to control where they go. Your personal property doesn't transfer with a transfer on death deed. Only the property in that deed does. So you want to be careful with that. You want to make sure you do have an estate plan. So back up. What's the executor do? Once the court appoints an executor or an administrator, their purpose is to administer the estate, pay the creditor claims, deal with federal and state tax issues, and finally distribute the remaining estate assets. The will has to be recorded where the property is located. I live in Fairfax County. Don't throw anything at me. But I have property here, right? My estate is going to be in Fairfax County, but to sell my property here, those documents have to get recorded down here, because we can't expect an abstractor to search all the counties in Virginia looking for my estate. My property's here, so my will has to be at least recorded here, okay? So that this county knows what's supposed to happen, okay? So now, the executor's power will either come from the will itself, which can include, so the will states, I'm giving this to my executor should sell this, blah, blah, blah. Or it can incorporate the statute 64-2-105, which can incorporate a whole slew of different authority that the executor has. So that the will doesn't have to sit here and look at, just like a power of attorney, it doesn't have to go through and list every single possible scenario that ever happens. By referencing the statutes, that executor has those powers, right? So it kind of gives us a cheat to shorten that document up and give broad powers, okay? If I died intestate, there is no will, so where am I going to get my powers to sell the real estate from? I don't have the power to sell real estate if I'm an administrator in an intestate estate. I have to get a court order to do so, right? So if I can't sell it, who sells it? The heirs. Anybody have a case with at least 15 or more heirs in it?
Yes.
Happens, yeah, right? And then what do? We're dealing with somebody who owned the property for a long time. They died. Maybe they had predeceased children, right? And in that case, without a will, then those kids step up.
Yep.
It can be a mess, and you got to track it down. So who do you need your listing agreement from? All the heirs. That's going to be fun, right? Who's got your Ancestry account? You got to start tracking everybody down. Or you can suggest that they get an administrator appointed. That administrator seeks an order to sell the property, and then we pay the proceeds into the estate. That's going to be a whole lot easier, isn't it? Right? That's one way we can help you get to the table when you have that big list of people and you got unknown heirs and all that nonsense. But it happens more than you think. It happens a lot. See, I'm only 25. This is what title's done to me. Title is, it's made it crazy. All right, so similarly, in a testate estate, if the will doesn't include the power to sell or incorporate that statute, the executor can't sell. The beneficiaries under the will have to do it. Okay? If the property in the will was gifted to a specific person, so 5 Oak Street is specifically gifted to Johnny, and the executor's trying to sell it, we're going to need Johnny to sign in that deed as well because it was his gift, right? So he's got to consent to that. If he doesn't consent to it, the executor is going to have to go and get a court order divesting Johnny of the gift. The court may grant it if we need to sell the real estate to pay off the debts of the estate, right? So the joke was when I had all my student loans was he who dies with the most debt wins, right? Because I didn't have anything anyway. But now I got a roll of dimes, so now if I die, my creditors are going to want pieces of those dimes. They're going to break open that roll. Right? I don't even know if banks give out rolls anymore, do they? So in that case, Johnny would have to join with the executor to sell the property. Okay? But here's the thing. Johnny could also sell the property because it was specifically gifted to him. The will, the probated will, the will was admitted to probate. That means the devisee, Johnny, can now sell the property without the executor joining in at all. So, does that mean he's free and clear of the creditor's claims? No, it does not. Creditors can go after the proceeds. So, yeah. But if the property was just going into the pot to be split up later, then the executor can usually sell if the will contains the power to sell. Okay, we talked about that. So in a case of no will to the surviving spouse, unless there were children from someone else other than the surviving spouse gets a third, the decedent's children get 2/3, and any predeceased children, their kids step up and take that person's share. If there's no surviving spouse, then to all the decedent's children and their descendants. If there's no kids and no spouse, then to the parents. If there's no parents, then to the siblings and their descendants. If there's no siblings, then it goes to grandparents, aunts, uncles, all the way down the line. My point here is that everyone thinks that, oh, if I don't have a will, the property is just going to go to the Commonwealth. Well, there's a long list of people that's going to go through before it gets to, you're going to get cousins involved before the Commonwealth gets it. So the theory that, oh, it's just going to go to the state and I'm good with that. No. I've seen cases where that's happened, right? But it's a long list of things that have to happen before that property gets to the state. Okay? All right. So remember that an administrator, the executor appointed in an intestate estate has no power to sell. So if you're meeting with John and he's telling you that he's Mary's administrator, he doesn't have the power to sell real estate unless he has a court order, right? The executor, just because I'm named in the will as the executor, doesn't mean I can sell the property. The will has to be submitted to probate, and the court has to appoint me as the executor in order for me to have any power. So just because I have a will that's not been probated, that means nothing. Absolutely nothing. That will's got to go through probate. It's got to go through the administrative process, which the whole purpose of is to get the property from person A down to person B, right? To transfer the title, okay? So in the case of an intestate estate, the heirs are going to sign, okay? Any questions on that? No? Okay. When is the surviving spouse going to be required to sign? Property's in my own name, but I have a surviving spouse. Right? She wasn't on the title. I do a will. We didn't get along. I wrote her out of the will, or I gave her $1. Here you go. Here's $1. Right? Is that all she gets? No. She can elect against the will and take what she would have gotten in an intestate estate. right? This is public policy because we don't want people to write their spouses out of their wills, right? We don't want them to impoverish their spouse. So the law gives them a right to say, take your will and shove it. I'm going to get what I'm due under state law, right? They have a right for 6 months from the ladder of admission of the will to probate or qualification of an administrator to make that claim. So if your sale is happening before 6 months has passed, we're going to need that surviving spouse to sign, even though she wasn't on title. Okay? The other thing is, if this was if this was our marital property, she has a life estate interest in that property. If this was our marital residence, rather. Okay? So property's in my name alone, but I die, right? My surviving spouse has the right to live there for as long as she wants, for her lifetime. Okay? Subject to the mortgage, subject to real estate taxes, all that good stuff. But basically, the heirs couldn't sell it without her also joining in. Okay? Because that was the marital residence. Right? So even though she's not on title, we're going to require her to sign. Now, let's say we're talking about vacant land. Would she still be required to sign? And more than 6 months has passed? No, because it's not the marital home, it's vacant land. Right? Then she wouldn't be.
You mentioned that subject to the mortgage, but if the mortgage, wouldn't that become the responsibility of the heirs?
Well, you don't pay the mortgage, you're not going to keep the property, regardless of your life estate.
But I mean, could she force the heirs to pay the mortgage?
No, everybody's got to pay. The mortgage company's not going to care. They need it paid. Yeah. And down here, you don't have judicial foreclosure. So it happens a whole lot quicker. You got to make sure that mortgage gets paid.
What if it was a reverse mortgage?
What about it?
So they give you so many...
They give you time to settle up. But when both borrowers have passed, they want to get paid, and they'll foreclose. And again, it's not a judicial process. The trustees get appointed, and they send the notices and put the publications out, and then the property gets sold. So it happens quick. For a reverse mortgage, also, all the borrowers would have to be on title. So, but foreclosure wipes things clean. So, what are we going to get? We're going to get the death certificate. We're going to ask if there's a will. If there is a will, we want a copy of it. We want a copy of the one that was filed at the court. We want the probate documents, including the qualification, the list of heirs, letters of administration. And then if we're dealing with an intestate estate, we're going to want affidavits of heirship. 2 affidavits from disinterested people, disinterested in the transaction, that say basically that the information that's on the list of heirs is true. Sometimes it's hard to get an affidavit of heirship because maybe somebody died a long time ago and nobody really knows this family. Things like that. You know, people have moved and, you know, time has gone by and time is not our friend, right? Just like gravity is not my friend. All right. Any questions on what to get in an estate? No? All right. How are they going to sign? They're going to sign out their full fiduciary signature. Diane Court, executive of the estate of James Court. Why? Diane doesn't want this to be her personal obligation. She wants the world to know she's signing on behalf of the estate, right? She doesn't want to be personally liable. If Diane had a judgment against her individually, when the estate went to sell, because she's now the executor, would that judgment attach to this property that's in the estate? No, would not, right? Because she's only acting, her only connection here is as an executor, as a fiduciary. So in that case, it would not attach. But if the judgment was against her as the executor, then it would have to be paid off. Okay? Next up, we're going to talk about trusts. There's two types of trust, basically. The first is a testamentary trust. That's a trust that you have within your will. Okay? When you die, the will gets submitted to probate. The executor has to follow what's in the will, and it may be to deliver the assets over to the trustee, and now you're controlling that asset from the grave, right? You're saying this is when it gets distributed, right? The other type is an inter vivos trust, which means a lifetime agreement, right? That's the example there is Matt Lynch goes and meets with Shaheen and puts together the Matt Lynch revocable trust. Matt Lynch is the trustee of, right? Next thing I do is I deed my real estate into that trust. So that makes the real estate a non-probate asset because the trust is going to say who gets the property. Now, when Matt Lynch goes to sell property that's in the Matt Lynch trust, right, I can pretty much just give Shaheen a certificate of trustee saying, I'm the trustee, it's my trust, I got the power to sell. That's all fine and good. But when I die, and Jeremy now is trying to sell the property as my successor trustee, well, who knows who Jeremy is? I don't know. He's just somebody saying that this is that he's that officer, right? So what are we going to need? The trust document, we're going to want to see that Jeremy is that successor trustee, right? If I'm still alive, well, how is Jeremy acting if I'm still alive? Have I been declared incompetent? Maybe. Is Jeremy my co-trustee? I could have appointed him my co-trustee. But we're going to need to see why he was appointed, how he got appointed. We're also going to need to see that he has the power to sell the property, right? So a trust is an estate planning document. It's still part of your estate planning toolbox. It's just one that takes your asset outside of probate. Okay, so there's no need to make any filings with the court. Inside of a trust, you can do all kinds of planning, right? If I die today, I got 2 kids. If I die today, do I want to give my 21-year-old son his share of all my assets right away, uncontrolled? Because that's going to show up in a shiny new sports car, right? Right? Here he comes in his new Mustang. I taught him better than that. He wouldn't buy the new Mustang. He'd get the old Mustangs. All right? So anyway, but I'd want to control it. Maybe I say, okay, you're going to get your share, but we're going to wait till you've grown up a little bit. I may delay his distribution to 25 or 30, right? Or maybe put a condition in there that he graduated college or completed his military service or accomplished trade school or something. Some kind of, it's my plan. I can put whatever I want in it, right? As long as it doesn't violate law, then I can put whatever I want in it, right? And so, same thing with a will. You can do that in a will as well, but that's what you do. That's what you would talk to your estate planning attorney about, right? And why wouldn't we just go to LegalZoom and download a document? We don't know if it's going to accomplish everything we want to do. We don't even know if it's going to be valid according to state law. I already told you I had a client this week. We turned down a power of attorney that they LegalZoomed it and it didn't have the power of sale. Even though it said right on top, Virginia power of attorney. Ooh. And guess what? It didn't have the power of a sale. I couldn't use it. And they're kicking and screaming. I'm like, I'm contained to the corners of the document. If you can find in that document where it says it, sure, I'll reconsider. But it's not there, right? I may be old, but I got my BJ's readers. 125. I can find any, if I'll borrow my wife's at 175 if I need to. But right now, 125 does me good, and I'll review that document. Right? Look. Now I'm smart, Matt. I'm smat. All right. So, prior to settlement, we want copies of the trust. We want the amendments. We want certification of trust in certain situations can be acceptable, such as if Matt Lynch is selling Matt Lynch's trust property, right? Then they can rely on my certification. But if somebody else is selling it as the successor trustee, we kind of want to verify that information, right? If I'm alive, but Jeremy says I'm incompetent, right? He remembers all the good things I did. And that one thing I said no to. Now he gets me. So now that letter from a physician, right? I'm incapacitated, right? What does the document say is needed? Does it say I only need one? Okay, great. But if it doesn't address it at all, guess what? I need two. Can it come from the facility manager? No, it's got to come from a licensed physician, right? Someone who can diagnose and treat. Let's say I have resigned and appointed somebody. This is going to be a written document. I'm going to want a copy of that, right? Let's say I'm in a trust and I can't be here for the sale. I'm alive. It's a revocable trust. But right now, I'm the only trustee. How can Jeremy sign for me? The property's in a trust. Rarely works. Rarely works because all the documents have to line up. The planets have to be in order, and it rarely works. If I'm alive and I'm competent, the easiest thing for me to do is amend my trust to make Jeremy a co-trustee right now and give him the power to act. That's the easiest thing to do, right? I'm alive, I'm competent, I can make that switch. It's just a signed, notarized document. Good to go. If your buyer is going to be putting property in a trust, guess what? The lender's going to need to review it. Just like powers of attorney, not all lenders will accept a trust. They want to look at it. They want to review it, make sure that they're okay with it, right? The quicker you get that to them, the less delay you're going to have in your closing, right? So let your buyers know. And if they're, you want all this information up front. You don't want to be coming back to them time and again. You want it all up front.
Well,
soon as, yeah.
TikTok attorneys don't teach us this. Everybody follows TikTok attorneys.
Yeah. I haven't seen those. I'm not on TikTok. Yeah.
Everybody attorney on TikTok.
Yeah. So what are we going to review? We're going to review who the trustee is, what the powers are, what happens if the trustor, if I die, is the trust revocable or irrevocable? If I'm alive and the trust is revocable, that means I can make that amendment to the document to make him my co-trustee right now, to serve while I'm serving. And the great thing there is I didn't have to resign. Or I could say he's the trustee, but just for the sale of this property, right? If it's irrevocable, that means it can't be changed. That means we're stuck with the document. We can't do anything about it, right? So you have to live and die by the terms of that document. And are there any specific provisions regarding this particular piece of property, right? Was it supposed to go to Johnny? Was it supposed to be held for maybe a special needs person? We don't know. Got to look at it. We won't know until we look at it, right? How are they going to sign? They're going to spell it all out. They got to spell it all out, right? All right, guardianships and conservatorships. If I have a power of attorney that's been determined not to be acceptable, or if I don't have a power of attorney at all, how is somebody going to complete that sale transaction for me?
Through the courts.
You got to go to court and get a guardian or conservator appointed. Conservators for the property. Guardian can also be guardian of a minor's estate. But generally in Virginia, guardians, we talk about the person. Conservator, we talk about the property. Same process. So the court appoints someone because the person is unable to manage their own affairs. They're mentally incompetent, and not able to manage their own affairs, be it for their own health or for their property, right? We need a copy of that court order. We need a copy of that court order because that court order is going to tell us what has to be done in order to sell property. A lot of times, the order that appoints the conservator will still require the commissioner of accounts in that jurisdiction to approve of the sale. What that means to you is you've got a ratified contract. You're already planning your next vacation. Go, hey, I got this contract, I'm ready. Guess what? Not so fast, because now the court has to approve the contract. The conservator can't go to settlement until they've approved that sale, okay? So we got to look at the document and see if it's a requirement that the commissioner of accounts be involved, okay? Sometimes they are, sometimes they're not. It really depends on the facts of the case. Can't give you a percentage. We just need it to be, we're going to need to see it in order to see what we have to do as title people to make that sale happen, okay? So if the order is coming from a different jurisdiction, you know, I live in Fairfax, I'm selling a property down here, my court case is in Fairfax. So we need a certified copy of that order from Fairfax recorded down here, so when we do that real estate transaction and look in the courts down here, we see it, right? Questions on that? Yes.
House is being sold with court appointed.
Conservator, okay.
Contracts were accepted, and another contract was submitted, but they didn't get it in before the commissioner suspended reviewing.
Okay.
Do these potential buyers that submitted this contract,
The first buyer or the second buyer?
the buyer that submitted this contract that was not reviewed, they believe that they have the right for the contract to be reviewed because according to RAIN, our real estate laws, all contracts should be given to the seller for review.
But the conservator accepted the other one before he got the second one.
He hadn't accepted the other one yet. He suspended review of contracts, of other contracts. So they had accepted one to give to the commissioner.
Before the second contract came in? All right, then he's accepted the contract. I mean, the other party can kick and they're still going to have to go to the commissioner. But you have a ratified contract.
I was just going to mention.
This is America. We have the right to make a bad deal. You know, had I waited a day and this guy's going to now pay me over asking price, you know, oops, that's just my bad timing.
They were just thinking that they had rights to, I don't know, sue the conservator for not accepting their offer or reviewing their offer.
If the conservator already accepted the contract, right?
Even as a seller, if I'm selling my home and you're my agent and I decide I like this offer, you can send me the offer. Whether I look at it is my prerogative. Like, what are they going to say if I decide I don't want to look at that offer? It's not like...
Right. They were being Google attorneys and saw that all offers are to be presented.
So they were from Williamsburg.
I don't have to give anybody a chance.
Okay. I mean, general concepts of contract law is once you've accepted it, you've accepted it. So, you know, so a better offer comes in a day later. I'm sorry, I'm already obligated to this guy. Guardianships and conservatorships are only valid during the lifetime of the person. Once the person dies, then the estate takes over. Okay? Their fiduciary role only during lifetime. Okay? If you're dealing with a disabled person, someone who doesn't have the power to, they're not competent and they don't have a power of attorney, or the power of attorney is invalid, right? The only way to get that transaction done is going to be through getting a conservator appointed. Okay? So it's very important to get that estate plan in order. Who needs an estate plan? When do you need it? Who are you going to call? There you go. You guys are awesome. They may even have me back. All right. How do they sign? They sign out the full thing. So we talked a lot about, signature authority, but for your own takeaway, for your own personal stuff, what does an estate plan consist of typically? A medical power of attorney for decisions over your person, if you can't make them. A financial power of attorney who's going to be able to take care of financial affairs, right? And you don't have to be disabled for that to happen. You can put that in place right now. I've had cases where the power of attorney was being used for settlement and the principal was right there at the table. But she was an old lady and preferred her son to do it. I did it that way for my own mother, right? She's like, you're in real estate. We used the power of attorney and I signed it. She was right there the whole time, right? Perfectly acceptable. Next thing you want to do, probably a living will. That's an advance directive. Why is that different from a medical power of attorney? Because that's where you make the decision today that if you're in a terminal condition and your doctors certify that but for that life-sustaining, that artificial life support you would otherwise pass, that it would be your decision to get removed from that life support, right? So that you're not making your family do it, okay? Whereas in a medical power of attorney, you're making that family member make that decision for you. So it's just another tool. Next thing you want to have a will. You want to get the big Gran Torino package, get the trust, right? Even if you have a trust, you're going to have a will to catch any assets that you might not have put inside the trust, right? It's like we call it a catch-all or a pour-over trust, right? What are some other estate planning tools that you can talk about? Transfer on death deed was mentioned, right? What is that? Right? That's just a statutory approved document that allows me to say, upon my death, I want these beneficiaries to have it, right? So like a trust, it's a non-probate document, meaning we don't have to get the courts involved. My beneficiaries only need my death certificate to show that they're the owners, right? So very easy, right? Do I give up control if I put my property in a transfer on death deed? I do not. During my lifetime, I'm free to mortgage the property, I'm free to sell the property. My beneficiaries are not involved in that decision. Their judgments do not get involved when I go to sell or mortgage the property, because their interest is contingent, meaning they don't get it until I die, okay? Now, when I die, then yeah, their judgment's attached to the property. I got 3 kids, one's a financial mess, his creditors attached to that property, right? Then his 2 siblings can go and have a conversation, right, on who's going to get what. You like that conversation? She's like, I've had conversations. All right, so we're at 2 o'clock. Woohoo! So before we leave, we got to do one exercise. I want everybody to lift their hand. Now lift the other hand. Okay, now put them down. And now you can say that you were at a meeting with Matt Lynch and it moved me. There you go. Thanks. Thank you, everybody. Thank you, Shaheen, for having me.